Good day, future lawyers. This is the case of Cordillera Global Network versus Pahe, April 10, 2019, by Justice Marvic Leonen. Facts. On October 27, 2011, the DENR car with clearance from then DENR Secretary Pahe granted SM Investment Corporation's request for a permit to cut and earthball the Benguet pine, alnus trees, and saplings that would be affected by the expansion of its existing mall, SM Baguio City, on Luneta Hill to increase parking and commercial spaces.
However, the permit's issuance was subject to several conditions, including the conduct of the public consultation with stakeholders and the procurement of an environmental compliance certificate. The City Planning and Development Office of Baguio City granted locational clearance for the expansion project. On February 27, 2012, Cordillera Global Network, representing concerned residents of Baguio City, filed a complaint against SM Investments Corporation, Secretary Pahe, Attorney Cuna, the Director of the Environmental Management Bureau, and Secretary Rogelio L. Singson of the DPWH. The first environmental case prayed, among others, that a temporary environmental protection order be immediately issued to enjoin SM Investments Corporation from cutting and or earthballing the 182 Benguet pine and alnus trees on Luneta Hill. Regional Executive Director Bagilat of the DENR CAR gave SM Investments Corporation the go signal to earthball the trees. Hence, SM began earthballing the Benguet pine and alnus trees. Pending resolution of the first environmental case, Cordillera Global Network filed an urgent motion for the issuance of the TEPO with a prayer for the conduct of an ocular inspection. That same day, the trial court granted the motion and issued a temporary environmental protection order effective for 72 hours. Upon receipt of the TEPO, SM Investments Corporation ceased its earthballing and transplanting operations. On April 13, 2012, Cordillera Global Network filed a motion to extend the TEPO. That same day, the trial court extended the effectivity of the TEPO to cover the pendency of the court proceedings in the first environmental case. On April 13, 2012, Judy Lynn Adahar and 75 other concerned Baguio City residents, Adahar et al., filed a new complaint against SM Supermalls, SM Prime Holdings Incorporated, and Regional Executive Director Bagilat. The two environmental cases and the petition then filed by the Cordillera Global Network to cite SM Investments Corporation in contempt for violating the TEPO were consolidated. Cordillera Global Network and Adahar et al. Both alleged that the cutting and earthballing of the 182 trees on Luneta Hill would severely damage the environment and health of Baguio City residents. They also assailed the regularity of the permits issued, further claiming that the expansion project violated zoning and environmental laws. Defendants asserted strict compliance with the relevant rules and regulations and emphasized that they immediately complied with the TEPO upon receipt from the trial court. The trial court dismissed the consolidated cases and lifted the TEPO. The RTC held that Cordillera Global Network and Adahar et al. Possessed the necessary personality to file the environmental cases under the principle of transcendental importance. However, their cases did not fall under any of the exceptions to the rule on exhaustion of administrative remedies. Thus, the cases were dismissible on procedural grounds. On appeal, the CA denied the appeals and upheld the findings of the RTC. Cordillera Global Network filed a petition for review on certiorari with prayer for temporary restraining order and writ of preliminary injunction. This court issued a temporary restraining order enjoining private respondents from implementing the assailed expansion plan and performing any cutting and balling of the trees in Luneta Hill. Private respondents SM Investments Corporation, as well as SM Prime Holdings Incorporated and Shopping Center Management Corporation, filed their respective comments with a motion to dissolve the temporary restraining order. This court gave due course to the petition and reiterated the previously issued temporary restraining order with modification. In their comment, SM claimed that the petition was defective since out of the 202 claimed petitioners, only 30 signed the verification and certification against forum shopping. The issues: 1. Whether or not the petition should be dismissed for having a defective verification and certification against forum shopping. 2. Whether or not the petition should be dismissed for raising questions of fact which are not allowed in a petition for review under Rule 45 of the Rules of Court. 3. Whether or not the petition should be dismissed for its failure to observe the rule on exhaustion of administrative remedies and the doctrine of primary jurisdiction. And 4. Whether or not the sealed permits issued in favor of private respondents were validly and regularly issued. Ruling: the petition is partly meritorious. Contrary to private respondents SM Prime Holdings Incorporated and Shopping Center Management Corporation's assertions, the failure of all petitioners to sign the document is not sufficient ground for the petition's outright dismissal. Jurisprudence confirms that petitioners substantially complied with the verification requirement. The 30 signatories provided the guarantee that 1. They had ample knowledge as to the truth of the allegations in the petition, and 2. The petition was made in good faith. For the certification against forum shopping, Altres versus Empleo stated that general rule that non-signing petitioners will be dropped as parties to the case. Nonetheless, there is an exception. When all petitioners share a common interest, the signature of one petitioner in the certification against forum shopping is enough to satisfy the substantial compliance rule. Petitioners all share a common interest, which is to declare the cutting or earthballing of the trees affected by the expansion project illegal. Hence, the signature of 30 petitioners to the certification against forum shopping amounts to substantial compliance with the requirement under Rule 45 of the Rules of Court. Second issue, it is well established that a review of appeals filed before the court is not a matter of right, but of sound judicial discretion. The Rules of Court requires that only questions of law should be raised in petitions filed under Rule 45, as factual questions are not the proper subject of an appeal by certiorari. It is not the court's function to weigh all over again evidence that were already considered in the lower courts. However, these rules do admit of 10 exceptions as listed in Medina versus Mayor Asistio Jr. Number 1, when the conclusion is a finding grounded entirely on speculation, surmises, or conjectures. 2, when the inference made is manifestly mistaken, absurd, or impossible. 3, where there is grave abuse of discretion. 4, when the judgment is based on a misapprehension of facts. 5, when the findings of fact are conflicting. 6, when the Court of Appeals, in making its findings, went beyond the issues of the case, and the same is contrary to the admissions of both appellant and appellee. 7, the findings of the Court of Appeals are contrary to those of the trial court. 9. When the facts set forth in the petition as well as in the petitioner's main and reply briefs are not disputed by the respondents. And 10. The finding of fact of the Court of Appeals is premised on the supposed absence of evidence and is contradicted by the evidence on record. Upon careful review, this court finds that this case falls under the exceptions in Medina, particularly number 4, when the judgment is based on a misapprehension of facts, and 8,
when the findings of fact are conclusions without citation of specific evidence on which they are based. Issue number 3, the general rule is to first exhaust the available administrative remedies before a party can bring a case to a court for judicial review. In connection with the rule on exhaustion of administrative remedies is the doctrine of primary jurisdiction. Under this doctrine, courts will hold off from determining a controversy involving a question within the jurisdiction of an administrative agency, particularly when its resolution demands the special knowledge, experience, and services of the administrative tribunal to determine technical and intricate matters of fact. However, Baraga v. Court of Appeals emphasized that the rule on exhaustion of administrative remedies is not a hard and fast rule. It may be disregarded when any of the following exceptions are present. It is not applicable 1. Where the question in dispute is purely a legal one, or 2. Where the controverted act is patently illegal or was performed without jurisdiction or in excess of jurisdiction, or 3. Where the respondent is a department secretary whose acts as an alter ego of the president bear the implied or assumed approval of the latter unless actually disapproved by him, or 4. Where there are circumstances indicating the urgency of judicial intervention. Said principle may also be disregarded when it does not provide a plain, speedy, and adequate remedy, when there is no due process observed, or where the protestant has no other recourse. Article 2, Section 6 of the Department of Environment and Natural Resources Administrative Order Number 2003-30 provides Section 6 Appeal. A new party aggrieved by the final decision on the Environmental Compliance Certificate or Certificate of Non-Coverage applications may, within 15 days from receipt of such decision, file an appeal on the following grounds: grave abuse of discretion on the part of the deciding authority or serious errors in the review findings. The Department of Environment and Natural Resources may adopt alternative conflict or dispute resolution procedures as a means to settle grievances between proponents and aggrieved parties to avert unnecessary legal action. Frivolous appeals shall not be countenanced. It is not disputed that petitioners were never a party to the application of environmental compliance certificates, both the original and amended, for the expansion project. Hence, they were never furnished a copy of the decision of the environmental compliance certificate, which would trigger the start of the 15-day appeal period provided for under Section 6. Issue number 4, petitioners failed to support their allegations that the issued locational clearances were improperly issued. Besides, if petitioners wanted to challenge the locational clearances issued by the Planning and Development Office of Baguio City, they should have filed an appeal before the Housing and Land Use Regulatory Board or HLURB. While Executive Order Number 72 may have devolved the agency's power to issue locational clearances to cities and municipalities, it did not remove its appellate jurisdiction over actions of local and regional planning and zoning bodies. The agency mandated with establishing standards and guidelines for land use plans and zoning ordinances. The HLURB has the necessary knowledge and expertise to pass judgment upon questions within its sphere of expertise. Questions on which zone the SM Pines Resort project and expansion project correctly belonged in and whether their locational clearances were validly issued should have been raised before the agency. It does not escape this court's attention that both the Regional Trial Court and the Court of Appeals missed private respondents' application for the cutting of 182 trees in addition to 112 already allowed in the earlier environmental compliance certificate merely through an amended environmental compliance certificate and almost 9 years after the original had been used. This court also notes the lower court's nonchalant attitude when it failed to notice the Department of Environmental and Natural Resources failure to distinguish indigenous long-standing pine trees from those recently planted when it issued the amended environmental compliance certificate despite the existence of Executive Order number 23. This court has time and again considered that the words in Article 11, Section 16 of the Constitution are not mere shibboleths. Section 16. The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. While the provision does not contain a specific act required by the state, it certainly mandates the sensitivity of both the Department of Environment and Natural Resources and our courts to acquire a standpoint that is protective of our ecology. Shortcuts into the process through which the state assures minimal impact on the environment, weighed against the profits to be generated by businesses, must not be tolerated. Commerce is important for human survival, but so is ecology. In addition to upholding what the law contains, let this decision affirm our human stewardship of the planet. We belong to the land, its waters, and its forest. Protection of the environment on behalf of our present and future communities is progress. During our watch, we will be on constant guard, not only on what is done beyond the law, but also against the hastened demise of the natural endowments entrusted to us. Wherefore, the petition is partly granted. The March 24, 2015 Temporary Restraining Order amended on April 19, 2016 is made permanent without prejudice to the filing of an application for a new environmental compliance certificate. This is in compliance with the conditions in the October 17, 2011 Memorandum as well as Executive Order number 23 and other applicable laws, regulations, and requirements.